Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and antitrust, also called competition. So, we're seeing in different jurisdictions around the world where there is a bit of an entanglement between data privacy, data protection, and antitrust laws. There's actually a particular case, the Lindenapotheke case, where the European Court of Justice made a really interesting finding or precedent in this particular case. And so this particular case is about pharmacies and information that people would give to a pharmacy as they're ordering drugs online, for example. So, like, for example, giving their name, giving their address, giving maybe the information about what they're ordering. That first of all, the this particular case stated that that information as part of that transaction is considered personal data, even before the person orders a particular thing, and even if the thing that they order is not a prescription medication. So that information is, they say, considered personal data under Article 9 of the General Data Protection Regulation. But in terms of antitrust, I think it was really interesting that this ruling, they basically said um, that competitors can sue one another over data protection breaches, especially if they feel that this particular thing has some type of anti-competitive nature to it. For example, let's say a gatekeeper, I'm just using it for lack of a better term, a bigger company has more access to data in some way, and if there is a breach in some way, there may be a situation where a competitor can sue that particular company, even if they're not directly related in the particular breach or the particular transaction. I think this case is a big deal. Also, we're seeing other cases in different jurisdictions around the world where there's a bit of a tussle between privacy and antitrust. For example, we've seen, especially like in the cable provider telecom space, where companies have said that, for example, they felt that Apple was uh, involved in anti-competitive practices because they wanted to keep their ecosystem closed. And so that's part of the fight that we're seeing in Europe around the Digital Markets Act, where the gatekeepers have to open up or allow, for example, side loading or some type of interoperable support to other companies around their tools. And it has been argued, for, especially companies that have, like Apple, they have more of a closed system, that this will create more privacy challenges. And so I am sure that we will see a lot more talk about these two, definitely in Europe, where there have always been some talk around competition and data practices as it relates to privacy. And I think we'll start to see that more even in the US, as these issues come up a lot more about how different companies interact with each other, how we can have a level of competition, and especially around maybe gatekeeper companies having more data than maybe these other smaller companies. And so I think it's just going to be a big issue that we're going to be talking about a lot more. I've said it, actually, I was interviewed by Bloomberg many years ago, and this is a topic that I brought up then around the relationship between data privacy and antitrust or competition. So I think it'll be an exciting time to see how these things intersect and how they flow together, because I think there is a relation there. That's it. Thank you.